On 3rd March 2016, an officer of the Indian Navy, Commander Kulbhushan Jadhav, illegally entered Pakistan and was arrested by the Pakistani authorities in the course of a counter-intelligence operation from Mashkal, Balochistan. At the time of his arrest, Commander Yadav was in possession of an Indian passport. He subsequently admitted to being a serving officer of the Indian Navy. Commander Yadav publicly confessed to his involvement in espionage, sabotage and terrorism in Pakistan upon the instruction of the Indian Research and Analysis Wing (RAW). Commander Yadav was tried, convicted and sentenced by the Field General Court Martial, and his appeal was denied by the Military Appellate Court. On 8th May 2017, India filed an application before the International Court of Justice, alleging a violation of Article 36 of the Vienna Convention on Consular Relations 1963 and asked the court to direct Pakistan to annul the decision of the Field General Court Martial and to provide consular access to India and to Commander Yadav. The ICJ delivered a judgment in the Yadav case on 17th July 2019 and ordered Pakistan to do 4 things. Number 1, inform without further delay Commander Yadav of his rights under Article 36 of the Vienna Convention on Consular Relations. Number 2, allow without delay Indian consular officers to communicate with and have access to Mr. Kulbhushan Jadhav, to visit him in detention and to arrange for his legal representation. Number 3, take all measures to provide for effective review and reconsideration, including, if necessary, by enacting legislation. And number 4, stay execution till such time that effective review and reconsideration of the conviction and sentence of Commander Yadav was undertaken. So basically, the judgment of the ICJ placed an obligation upon Pakistan to provide effective review and reconsideration of the sentence and conviction of Commander Yadav, while the choice of means to do so remained with Pakistan. Pakistan immediately complied with 3 out of the 4 directives of the court. Pakistan did the following. Number 1, Commander Yadav was informed of his rights under Article 36 of the Vienna Convention on Consular Relations. Number 2, Pakistan invited a diplomatic officer of the High Commission of India in Islamabad to meet with Commander Yadav. And number 3, Pakistan continues to maintain a stay on the execution of Commander Yadav pending effective review and reconsideration of the conviction and sentence of Commander Yadav. Moreover, notwithstanding a legal obligation to do so, Pakistan arranged a second consular meeting between Commander Yadav and officers of the Indian High Commission so that a legal representative could be appointed for Commander Yadav by the Indian High Commission. Although the laws of Pakistan provide for the right to review, to ensure that full weight is accorded to the letter and spirit of the judgment of the ICJ, on 20th May 2020, Pakistan enacted the International Court of Justice Review and Reconsideration Ordinance 2020, which became an act in December 2021. Pakistan repeatedly requested India to avail of the remedy provided by the government of Pakistan and file a petition at the Islamabad High Court to initiate the process for the review and reconsideration of the conviction and sentence of Commander Yadav, but India refused to do so. The judgment of the ICJ requires the understanding of certain legal issues that are crucial to fulfilling the obligation placed upon Pakistan by the International Court. With regards to the scope of the obligation of providing effective review and reconsideration and its modalities in the context of the principles and law of the ICJ, Pakistan can decide how to carry out the review and reconsideration of the conviction and sentence of Commander Yadav. The ICJ has stated that the choice of means is left to Pakistan, and Pakistan shall take all measures to provide for effective review and reconsideration of the conviction and sentence of Commander Yadav, including by enacting appropriate legislation, which Pakistan has done. The direction of the ICJ is in line with its previous jurisprudence in the Legrand and Avena cases. However, it is important to note that Pakistan's right to choose the means of review and reconsideration are not without qualification. The ICJ has specifically stated that the obligation to conduct review and reconsideration is an obligation of result, which means that the review and reconsideration has to happen under all circumstances and it must be performed unconditionally. This also means that the burden to provide effective review and reconsideration of the conviction and sentence of Commander Yadav falls on Pakistan as an obligation of result. And since India has refused to file a petition under the 2020 Act, a petition for the appointment of Commander Yadav's legal counsel was filed by the government of Pakistan before the Honorable Islamabad High Court on 21st July 2020. Since then, monthly hearings have been held before the Islamabad High Court, in which the court has requested the Indian High Commission to appear and assist the court in the matter, but the Indian High Commission has refused to do so. Pakistan is a responsible sovereign that is cognizant of its international obligations and remains fully committed to implementing the judgment of the International Court in letter and spirit.